jurors have left the courtroom. Thank you. Please be seated. All right. With regard to further proceedings in this case, Mr. Chernoff, would you like to be heard?
Judge, you're asking about sentencing?
Any motion and probation and sentencing. Dr. Murray has a statutory right to speedy sentencing within 20 court days after today's date, which means on or before December 8th, 2011. I do not believe we have a probation report. We may, but I haven't reviewed any documentation, and I don't think we do. So it's up to you what date.
We were discussing the sentencing, possible sentencing dates, and we were talking about 3 weeks.
If you have a date that you're suggesting, let me know so then I can turn to the people.
Give me a second, Judge.
Please. Defense counsel are conferring.
Your week on November 22nd is that whole 21st. That whole week is not dark, is it?
We are open on the 21st and the 22nd. We are not in session the remainder of the week.
What about the 22nd? Is that something that you can do?
I can.
Is that sufficient time for a probation report?
It's
to go to the week of the 28th, if that's possible, Your Honor.
What is the schedule of probation on that?
2 to 3 weeks. It's very difficult to get a report within a 2-week time frame. My suggestion is that it be the week thereafter. The problem I have is I'm starting a major case on the 29th. If it means I have to go to the 30th, I'll do that. If we can start on the 29th, I can adjust the case.
Judge, I'm sorry, you said you're starting on the 29th a case? Is that what you're doing?
I was. I can do probation and sentencing on this case on the 29th as 13 of 20 if you want me to.
Yes, Judge. That will fit everyone's schedule, and Mr. Walgren, I believe, seems to be okay with that. So
let me just ask before we go to the next step. Is Tuesday, the 29th of November, acceptable for the people?
It is, Your Honor.
Thank you. With regard to further proceedings in this case, and Dr. Murray's status, do you want to be heard on that, Mr. Walgren?
I would, Your Honor.
You may.
At this time, Your Honor, the people would ask that the defendant be remanded into custody. He, as the court is well aware, has had over approximately 2.5 years to prepare for today's date. He's now a convicted felon and has been deemed the causative factor in Michael Jackson's death. At this time, we would ask that he be remanded with no bail pending sentencing on November 29, 2011. Thank you.
Thank you, Mr. Walgren. Mr. Chernoff, I'll hear from you.
all the causative factors for remand do not apply in this case. For 18 months, Dr. Murray has been on bail, has not violated any of the rules of the court, has not been a flight risk, has not been a danger to the community. If he continues that way, he has family obligations that he has to take care of. The fact that this was a possibility doesn't mean that those obligations don't need to be taken care of. There's no reason to remand him under the circumstances, and we ask that you release him OR until sentencing date of the 29th of November.
Is the matter submitted, Mr. Chernoff?
It is.
Mr. Walgren?
Yes, Your Honor.
Thank you. The court takes into account the factors in Penal Code sections 1166 and 1272. Throughout this trial, Dr. Murray was presumed innocent, and certainly there is a constitutional guarantee of bail to pre-conviction status. Dr. Murray has been convicted of a felony by the jury. The jurors found beyond a reasonable doubt, unanimously, that Dr. Murray is in fact guilty of the crime of involuntary manslaughter. There is no statutory right to bail based upon this felony conviction. The court does evaluate the defense request for continued release on OR and bail pursuant to the provisions of the penal code sections to which I referred. The defendant shall be committed to the proper custody of the county to await judgment of the court upon the general verdict unless, upon considering certain factors, the evidence supports a decision to allow Dr. Murray to remain out of custody on bond. The first factor is the protection of the public. Quite frankly, I feel that that is a significant and demonstrable factor in this case, and public protection, as far as I'm concerned, dictates that the defendant be remanded without bail in view of the fact that Dr. Murray has been convicted of a crime involving homicide. This is not a crime involving mistake of judgment. This is not a crime involving administration of drugs per se. This is a crime where the end result was the death of a human being. That factor demonstrates rather dramatically that the public should be protected. Secondly, the seriousness of the offense charged and proven. The offense charged and proven in this case is a homicide, and the homicide is predicated upon criminal negligence in this case. As far as I'm concerned, that factor is a significant factor in terms of remand. Third, the previous criminal record of the defendant. As far as I know, that criminal record is non-existent, and that is a factor which would indicate to the court that Dr. Murray should remain on his posted bond. The fourth factor is the probability of the defendant failing to appear for the judgment of the court upon the verdict. Dr. Murray has made all of his court appearances. He has been represented by counsel. He has made appearances in the past. Quite frankly, I don't know if Dr. Murray would in fact make those appearances in the future, since he now is a convicted felon, and Dr. Murray has significant ties outside of the state of California. So I genuinely am not sure about this factor. The fifth factor is, once again, an overriding consideration, and that is public safety. Dr. Murray's reckless conduct in this case poses a demonstrable risk to the safety of the public. If Dr. Murray remains out of custody on bond, and even though Dr. Murray is a medical doctor, and even though he has been practicing, public safety demands that he be remanded. Based upon my evaluation of all of these factors, I conclude that remand is appropriate. Dr. Murray is remanded to the custody of the Los Angeles Sheriff with no bail, and in the interim, he is to be kept in the care and custody of the Sheriff and ordered to appear for further proceedings and formal probation and sentencing on 29 November 2011 at 8:30 a.m. in this department. I expect that the people will have specific restitution. We can wait a few moments. Specific restitution-related issues in